Does everybody agree we can record?
Yeah.
Yes.
Yes, please.
Okay, so good. All right, let me give you a hint about screen sharing. If you want to reduce the size of the slide and see more of the people, you just move the line between the slide and the people left or right, and you'll see that it will adjust the size of the slide for you. So you can see more people. A lot of people don't know how to do that on Zoom. This talk, because now we're getting into cases, I'm going to discuss a lot of the cases and I'll talk about the facts. I'll try and go through slowly. I do have time built in for questions.
Okay, Arthur, I'm going to mute everybody, and so you'll have to unmute yourself.
Ah. There we go. Okay, can everybody hear me?
Yes, it's good.
Okay, very good. On January 21, 2010, the Supreme Court announced its decision in Citizens United versus the Federal Election Commission. The court held that certain provisions in the McCain-Feingold Act that regulated corporate campaign spending on political issues constituted unconstitutional restrictions on free speech. They ruled that Congress did not have the right to limit what a corporation could or couldn't spend to buy access to express its views on political issues. Thus, in the context of the First Amendment's protection of political speech, corporations enjoyed the same rights as people. This decision quickly became a flashpoint. Liberals uniformly denounced it as unreasonably increasing the power of the 1% to drown out other voices. Conservatives praised it as necessary to allow more diverse voices to be heard, to counter the perceived bias of what they call the liberal media. And a week after why isn't this working? I want to shift slides.
You might have to click on your screen first. And
there we go. Okay, now let me click on the screen. Nope. Oh, there we go. Okay. A week after the decision was announced, the country saw President Obama denounce it in the State of the Union address, while Justice Alito angrily shook his head saying, "Not true." And it has become a mantra of progressive candidates to pledge to overturn the decision by hook or by crook. The left side of the Democratic Party, such as AOC or Bernie Sanders, argue that decisions like Citizens United and Shelby County versus Holder, which I'm going to talk about next week on voting rights, are why the Supreme Court should be expanded. And they argue that only doing so would overcome the present 6-3 majority of mostly younger judges who oppose most every progressive policy, whether it's voting rights, racial justice, immigration, gun control, abortion, or the death penalty. And if you look at the slide that I've got there, I put up the Supreme Court as it exists now with the year appointed, and on the right-hand side, which I can't see because your pictures are all there, is the ages. And you'll see that Amy Coney Barrett's only 49 years old. And none of the other than Justice Alito, none of them are over 70, except for Justice Alito and Clarence Thomas. So what I'm going to do is I'm going to start with a brief synopsis of the case itself. I'm going to look at 5 critical Supreme Court cases on campaign finance that were decided before Citizens United reached the court. And this is necessary because you can't really understand the Citizens United case unless you have an understanding or at least been exposed to what preceded it. And there'll be breaks for questions. And then we're going to have a very close look at the Citizens United case and the dissent. And that should take us to the break. After the break, it's time for a bit of history. The history of corporations themselves and how they're treated, and the evolution of the First Amendment's free speech protections. And as I summarize the case, as we think about these issues, and you think about the Citizens United case and what you might have read about it, think about this. Mitch and McConnell and the ACLU were on the same side in this case. We have a perception of the ACLU, but they're adamant on free speech. They are opposed. The ACLU takes a position that there should be no limitations on free speech. Citizens United was a nonprofit corporation dedicated to political advocacy. Its annual budget ran about $10 million a year, raised mostly from donations from both individuals and corporations. In 2007, it produced Hillary, a highly critical documentary on Hillary Clinton's life and career. Citizens United intended to release it on video on demand within a month of the early 2008 primaries. The film had been financed by various sources, including several political action committees that Citizens United controlled, and by Citizens United itself directly from its general corporate account. But Citizens United had to deal with the McCain-Feingold Act, formerly called the Bipartisan Campaign Reform Act, BCRA. And I'll be referring to it as either BCRA or as McCain-Feingold. And it was designed to cure two ills that had not been cured by earlier legislation. One was the advent of soft money issue advocacy not directly tied to official campaigns that flooded our television screens during the lead up to elections. The other was a perception that an avalanche of money from corporations and labor unions was financing political parties and federal election campaigns. Now, where this act impacted Citizens United was that the act contained a provision that barred a corporation or a union from using their general funds to finance political speech for or against a potential candidate for federal office within a specific number of days before a primary or general election. It was 30 days before a primary and 60 days before a general election. And if they did so, it was made a criminal offense. So Citizens United, not wanting to risk a criminal conviction, filed a lawsuit in the United States District Court for the District of DC against the Federal Election Commission, seeking what they called declaratory relief. That is a declaration by the court that certain sections of the McCain-Feingold, including the section that barred them from using their general corporate account money for political speech shortly before elections, constituted an unconstitutional limitation on their right on free speech. Now, relying on prior Supreme Court cases, the lower courts, the District Court and the DC Appellate Court, the Circuit Court for the District of Columbia, ruled against Citizens United. So Citizens United sought a hearing in the Supreme Court, which was granted. Now, when a party seeks Supreme Court review, it's called a writ of certiorari. You might have heard that or seen it spelled. It's basically a writ asking the Supreme Court to hear their case because it involves a fundamental federal question that's important. And the Supreme Court has total control over its own docket. The only kind of case that it is required to accept is a lawsuit between two states. It has original jurisdiction and it's got to take those cases. But otherwise, it has complete control over its own docket. It can decide whether to hear a case or not hear a case. And it decides to hear a case if any 4 of the 9 justices want to hear it. And so that's what happened here. The Citizens United case got their writ of certiorari, and the case was scheduled for argument in 2008. The argument, it was put over, it was argued in 2009, and as I explained, that the decision came out in January of 2010. Now, what's important to understand is the key precedents that led up to it, and there were 5 of them. And I know this slide has a lot of language on it, but what it has is I've given a brief summary of each of the cases, but what I'm going to do now is go through them on these 5 cases, what they were about and what they held, because that's important to understand the Citizens United case. Because the Supreme Court had wrestled for years over the interplay between free speech, corporations and campaign spending's impact on free and fair elections. And these 5 cases are really relevant. There are more than 5 that I could put up here, but I limited myself to what I thought were the 5 most important ones. The first is Buckley versus Valeo, V-A-L-E-O, decided in 1976. The case concerned a challenge to the Federal Election Campaign Act of 1971 that was then strengthened by Congress in 1974 after Watergate. This was the predecessor to the McCain-Feingold Act. The case in Buckley versus Valeo had 6 separate opinions. The judges were all over the place. And a 5-4 majority, which controlled, basically said, yes, the act is okay to the extent that it limits contributions by non-candidates to campaigns, but it distinguished contributions from expenditures. The court upheld provisions that limited what people were allowed to contribute to a candidate's campaign chest, because the state has a compelling interest to prevent corruption and even the appearance of corruption. The idea that candidates are selling actual favors or selling access. So limiting contributions to a candidate's campaign chest was proper. But the court struck down provisions that limited what candidates and their supporters could spend on political speech. The court reasoned that obtaining access to audiences goes hand in hand with what is being said. So spending money to facilitate access to avenues of communication is functionally synonymous with speech itself. The First Amendment requires strong protection to foster the most wide-ranging discussion of political ideas and positions. So limiting expenditures is a direct and substantial restraint on speech itself. Now, this distinction between contributing to candidates and spending to get a message out is important. The court will almost universally has allowed limits on the former, but as we'll see, it has taken a very dim view towards any limitation on expenditures. The second case is First National Bank of Baladi. This is a case that arose in Massachusetts under Massachusetts state law. Now, Massachusetts had a provision in its law that prohibited a corporation from spending money for or against a candidate or a ballot issue, except when, quote, a question that materially affects the corporation's property, business, or assets, close quote. Now, the bank wanted to advocate against a proposed state tax law that only applied to individual taxpayers, not to corporate taxpayers. It sued to say that it should be allowed to do so. It lost, and it was appealed to the Supreme Court. And the Supreme Court granted certiorari, heard the case, and decided that, yes, the Massachusetts law was an unconstitutional restriction of free speech. And the case boiled down to 3 points that the court made. The first was that political speech doesn't lose First Amendment protection because the corporation can't show a direct material impact on its business. In other words, just because the corporation wasn't directly impacted by the law didn't mean that the corporation shouldn't have the right to express its views on that law. Secondly, Massachusetts law was designed to promote individual citizens' voices on political issues and not have their relative voices drowned out by corporate money. The court held that this was not a sufficiently compelling state interest to justify the restraint on free speech on a public issue. And the third point they made was if a law violates freedom of expression that the First Amendment was designed to protect, the identity of the speaker and the nature of the speaker doesn't permit restraint on the speech that's otherwise entitled to protection, even if the speaker is a corporation. And I'm going to read a quote that I underlined it, I put it in italics in my notes. The concept that the government may restrict the speech of some element of society to enhance the relative voice of others is foreign to the First Amendment. The concept that the government may restrict the speech of some element of society to enhance the relative voice of others is foreign to the First Amendment. And this by the way, is at the heart of what the Citizens United Court ruled. Now, this case, Baladi versus First National Bank of Boston versus Baladi, was a 5-4 decision with no clear liberal conservative division. The majority were moderates. Justices Powell, Berger, who was then Chief Justice, Potter Stewart, Blackmun, and Stevens, some of whom were actually quite liberal. And the dissenters were a combination of liberals and conservatives. Brennan and Marshall, with conservatives, Whizzer White and Rehnquist. So you don't always see this clear liberal conservative line. The next case is the Federal Election Commission versus Massachusetts Citizens for Life, decided in 1986. The case involved a single-issue nonprofit corporation expressly formed to raise money from like-minded people to advocate against abortion on demand. The entity engaged in no other business activity. It had a small board, a 3-person board of directors, its incorporators. It had no shareholders. There were no dues, and all of its money came from contributions from individuals who supported its cause. It neither solicited nor accepted money from corporations, unions, or other associations. It only accepted money from individuals. Now, shortly before an election, it mailed a newsletter to a broad mailing list recommending that voters should vote for certain candidates who agreed with their position. The Federal Election Commission filed suit alleging that this nonprofit, Massachusetts Citizens for Life, violated the provision in the act that barred corporations from using its general funds for specific political advocacy relating to elections. Now, this issue was not in the Buckley case. Justices Brennan, Marshall, Powell, O'Connor, and Scalia, go figure, you got Thurgood Marshall on one side and Justice Scalia on the same side of a free speech case, agreed that with the Massachusetts Citizens for Life, that Congress did not intend that entities like it, small entities that only accepted money from individuals, were subject to the law against corporations using money from their general accounts for political speech before elections. And further, if the ban did apply to an entity like Massachusetts Citizens for Life, it was an unconstitutional restraint on free speech. First, it didn't serve an anti-corruption purpose of regulating big money from large entities. And secondly, the financial reporting and disclosure requirements and limitations were unreasonable when applied to a single-issue nonprofit corporation that engaged in no other activities, had no shareholders, and was neither solicited nor accepted money from any corporation or union, but only accepted money from individual taxpayers. Now, the fourth case is very similar to Massachusetts Citizens for Life, except that the corporation involved is quite different. And one of the things that when you're talking about Supreme Court cases, in fact, any legal case, it's really important to focus on the facts of that case, because those are the facts that the court is ruling on. And although it makes general pronouncements, those pronouncements are based on the idea that they will apply to cases of similar facts, or where the entity, the point they're making applies to entities in general. And so it's always important to understand and think about cases in the context of the factual situation in which the case arose. So this case, Austin versus Michigan Chamber of Commerce, which came out in 1990, is, you'll see, Michigan state law, similar to the law under consideration in FEC versus Massachusetts Citizens for Life, barred corporations other than media corporations from using money in their general treasury accounts in connection with state elections. That's what the Michigan state law applied. Now, one of the things that you'll find frequently is when Congress passes a major piece of legislation, frequently states will pass a similar piece of legislation within their state law. We'll see this when we get to the religion cases in 2 or 3 weeks from now, or 2 weeks from now. But corporations under Michigan law were permitted to set aside unlimited money in designated political accounts identified for that purpose. The Michigan Chamber of Commerce was a nonprofit corporation, but it had thousands of dues-paying individual and corporate members from all over Michigan. And the Chamber of Commerce used these dues to provide a wide variety of services, most of which had nothing to do with political issues. Now, it wanted to use its general account or its treasury funds to buy ads for certain candidates. And it filed a relief action in Michigan State Court claiming that the Michigan law was unconstitutional. The Michigan Supreme Court ruled against it, so it applied to the Supreme Court of the US for certiorari. Now, one of the things that the US Supreme Court has the right to do is take cases that involve federal issues over state law that have already been ruled on by the highest court in that state. So if a state court makes a ruling involving a US constitutional issue on a state law, then once the highest court in the state has made that ruling, the Supreme Court can hear the case. So that's how the case gets to the Supreme Court. The Supreme Court upheld the Michigan law. It addressed two issues. First, did the Michigan law create an undue burden on political speech? And secondly, if it did create a burden, was it narrowly tailored to serve a sufficiently compelling state interest? So you have two issues here. Was there a burden on free speech? And even if there was a burden, was it narrowly tailored and did it serve a compelling state interest? Now, the court noted that the basic rule is that any law that restrains political speech presumptively violates the First Amendment. But the court found that Michigan's interest in preventing corruption and even the appearance or the possibility or perception of corruption was a sufficiently compelling state interest. And the opinion noted that corporations enjoy privileges under state law. They have limited liability. They have perpetual life. They have favorable treatment to enhance its ability to raise capital and make money for its investors. And all of this justifies a certain amount of regulation. So on the second part of the question, the majority held that Michigan's law was narrowly tailored to precisely target to address the distortion caused by corporate spending because corporations remained able to express their views by setting aside designated funds for that purpose. The court noted that the Michigan Chamber of Commerce was large, it had thousands of dues-paying members, and it provided a large menu of services apart from political advocacy. The court distinguished Massachusetts Citizens for Life on factual grounds, noting the many differences in size, scope, and source of funds and varied and diverse activities between the Michigan Chamber of Commerce, which had multi-purposes, thousands of dues-paying members, and provided many services having nothing to do with political speech, and the single-issue Michigan Citizens for Life entity. And the decision was 6-3. And the dissents were Justices Kennedy, O'Connor, and Scalia. And you'll note that Kennedy and Scalia were on the court when in 2009, and they were the dissenters here. Now, the fifth case after Austin that I want to talk about is Citizens United versus McConnell versus the Federal Election Committee. Mitch McConnell filed a lawsuit claiming that the McCain-Feingold Act was unconstitutional in its entirety. Now, the Supreme Court consolidated for argument 11 separate cases that sought to hold unconstitutional different parts of the McCain-Feingold Act. For those of you who remember when we talked about Brown versus Board of Education, that also involved 5 different lawsuits that the Supreme Court consolidated for argument. When the Supreme Court has a lot of cases in front of it involving the same or similar issues that it feels can be decided together, it will consolidate all those cases for argument, which is what happened here. And then the case is known by the name of the lead case. In the school desegregation issue, it was Brown versus Board of Education, although the main arguments were between South Carolina and the NAACP. So here the lead case is the lead case is the McConnell case. As far as relevant here, a joint opinion, and this is unusual, there was a joint opinion by Justices Stevens and O'Connor that in part was joined by Justices Souter, Ginsburg, and Breyer, upheld the provisions restricting the use of corporations or labor union general funds for certain types of political speech before general and primary elections. Citing Austin versus Michigan Chamber of Commerce, they held that the provision served a compelling state interest and it was sufficiently narrow. Corporations were not totally prevented from political advocacy because they were free to set up separately segregated funds or political action committees with separate funds for doing that. The three dissenting justices, Kennedy, Thomas, and Scalia, objected to upholding restrictions on the corporation spending on political speech and firmly believed that Austin versus Michigan Chamber of Commerce had been incorrectly decided and should be overruled. Now, I have a note here in my notes that I've been talking from that I have questions before I get to Citizens United, the Citizens United case, which is the next thing on my list. So are there any questions that anybody wants to add as at this point of where we are before I get to the Citizens United case?
Well, I'll ask one. This consolidation, I hadn't really been aware of that. So who then serves as the lawyer? Do all of the different cases get together and decide how they're going to argue their point?
Yeah, they have a certain amount of time and the council will get together and decide how they're going to divide up the argument and who's going to take the opening and who's going to take the closing, and how they're going to divide up the time. And usually what they do is they figure out who the best one of them is and let him carry the argument. Because if you carve up that time in too small doses, you're not going to get your point across, because in Supreme Court arguments, if anybody's ever listened to them, you don't get to just make a 15-minute speech. It's not like here where you can mute the justices and make your point. There, from the minute you open your mouth and say, "May it please the court," you're going to get justices peppering you with questions. And you have to be able to both respond to those questions, and at the same time, make the main points you want to make. Any other questions? Okay, let me continue. It should come as no surprise that the Supreme Court decided to hear Citizens United's appeal. Roberts, as Chief Justice, and Samuel Alito had joined the court, replacing Rehnquist, who had died, and O'Connor, who had retired. And remember, Justice O'Connor was one of the writers of the opinion. She had agreed in the Austin case and was one of the co-authors of the opinion in the McConnell case. Alito was and is a member of the Federalist Society, an association of conservative and libertarian lawyers that had advocated against imposing limitations on campaign financing. And the five of them, Kennedy and Scalia, who had dissented in Austin, and Justice Thomas, Roberts, and Alito decided the case with Kennedy writing the opinion. And by the way, there's a line here that I always liked. Most legal scholars will tell you that the way to predict the outcome of the Supreme Court cases, that the first step is being able to count to 5, because that's what it comes down to. The opinion prioritized the presumption that unfettered political speech was to be protected at all costs. And let me go back to screen share here because I got something to show you. Share, click, and here it is. The first, and here's, I put this up because it's a key quote in the case. If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens from engaging in political speech which is indispensable to decision-making in a democracy. And this is no less true because the speech comes from a corporation rather than an individual. It's not that corporations have the same rights as people, it's that the distinction between a corporation and a person when it comes to free speech doesn't make a difference. Thus, any limitation on political speech is questionable. It would be permitted only under strict scrutiny if the court found that the limitation was supported by a compelling government interest and was narrowly applied to serve that interest with the least possible amount of restraint. And let me stop sharing. Needless to say, the majority found that the ban on corporations spending their general funds on political speech shortly before elections didn't meet that test. And their argument went as follows, and I've got 4 points to make here. The first is that the Federal Elections Committee has a great many rules and regulations concerning how, when, and under what conditions corporations could use their money to engage in political speech. So a corporation really had no alternative to first seek clearance from the SC at the risk of being later found in violation of the act subject to criminal or civil penalties. In other words, they're saying these regulations are so tough that it's impossible for a corporation or its lawyer to figure with exact accuracy whether or not they're right or wrong. And that the only way they can really protect themselves is to go into court first and get a judge to let them know if they're right or wrong. And what the court in the Citizens United case said is that this is virtually a prior restraint on political speech. If you've got to go to court to find out whether or not you can make the political speech you want to make, that's prior restraint, and the First Amendment doesn't allow that. The second point they made is that the alternative of only using separate segregated funds with the corresponding required disclosures on their financial statements was unduly restrictive as a condition of engaging political speech. Why should a corporation have to go through a rigmarole of satisfying generally accepted accounting principles in setting money aside in certain times in order to engage in political speech? That's not being sufficiently narrow enough. The third point they made was that singling out corporations for special limitations on expenditures ignored the fact that wealthy individuals and other non-corporate associations spent equally heavily and were not subject to the same limitations. To me, Sheldon Adelson, the Koch brothers, George Soros, Michael Bloomberg, and a host of others come to mind. And the last point, the fourth point I want to make, is that under McCain-Feingold, media corporations, newspapers, broadcasters, et cetera, are exempt from any limitations for spending on political speech. That's their business, and their exemption is necessary to protect the media's independence and the free flow of ideas, and is really required because to the free press idea. And the majority said there's no compelling reason why non-media corporations should be published for engaging in political speech that media corporations can make with impunity. And so for all of these reasons, the court rejected the central holdings in the Austin versus Michigan Chamber of Commerce case. Anti-distortion and preventing the appearance of corruption did not constitute a compelling state interest that justified restricting political speech. And the ability to spend through separate, dedicated, segregated accounts did not afford a reasonable alternative to using their general funds. The benefits from outlawing free, unfettered political speech outweighed any government interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. Remember the language in the Baladi case, the court cited that. The idea of suppressing one voice to enhance the ability of other voices to be heard is foreign to the First Amendment. So the Austin case was specifically overruled. Quote, the First Amendment does not permit Congress to make categorical distinctions based on the corporate identity of the speaker and the content of political speech. Now the dissent, Justices Stevens, joined by Ginsburg, Breyer, and Sotomayor, found fault with just about every point made by the majority. Now, the dissent's over 25 pages, and I'm not going to go through all of it, but I want to note a few of its key points. First, the dissent argued that the statute, the McCain-Feingold Act, did not materially limit free speech. Corporate Citizens United could have used its existing money in its PAC to finance and promote the film. The only limitation was that Citizens United could not use its general funds to promote the film within 30 days of a primary or 60 days of a general election. Thus, no speech was effectively banned. They could have put the movie out earlier. They could have, for promoting the movie during that short window period before elections, they could have used other money than their general account. Justice Stevens, who wrote the main dissent, noted that there were many good reasons to corporate treatment differently than individuals. Corporations receive special treatment under state laws, such as limited liability, centralized management, perpetual existence. Corporations could not vote or hold office. Corporations were creatures of state law, and there was a long history of their being regulated. The other point, the last point I want to make about the dissent is that the dissent argued that corporations could be controlled by people not necessarily loyal to the United States. State laws do not limit foreigners' rights to incorporate in the United States. For state laws do not limit the right of a foreign corporation to own a controlling interest in stock or to designate who can serve as officers and directors. What the majority said on this issue was that because Citizens United wasn't a foreign corporation and there was no foreigners involved, this issue was not before the court. So their ruling did not say that it was either, their ruling in Citizens United specifically did not address this issue. Therefore, as far as the majority was concerned, we don't have to decide this issue now, and we can make a general ruling, which applies to domestic corporations owned by Americans. And that's as far as this ruling goes. So we're not holding that this does not open the door to foreign interests. That's what the majority said. Now, in veiled language, the dissent criticized the case as a blatant example of judicial activism that overruled an act of Congress and prior decisions of the Supreme Court in a long history of regulating courts differently than people. To the four dissenters, the real basis of the court's decision is that 5 justices just didn't like Austin versus Michigan Chamber of Commerce, which was decided between Justices Thomas, Roberts, and Alito had joined the court. That was the dissent saying, this is judicial activism. These 5 guys don't like the prior decision. They want to change the law. They thought that the decision made 10 years ago was improper, and they want to change it. But they didn't have any really solid reason for doing so, other than polemics. That in effect they made a mountain out of a molehill. That Citizens United really wasn't restricted all that much, and they created a mountain out of a molehill to try and come up with a way to rule the case the way they wanted to. You know, judicial activism has been described as a judge making a decision that you don't like. That's at one level, that is a definition of judicial activism. Okay, I've been going for about 40 minutes, so let's have questions at this point about the case, because we can take a small break after this. I'd like to, and then I'm going to get into some history. But are there any? Let me open the floor to questions at this time about Citizens United. I've done what I could. I hope it wasn't too involved or too complex, or that I was at least understandable.
Well, I'll ask one then. So it seems to me that the thing that's always been puzzling is to treat a corporation as a person. So what did they say about this personhood argument? I would think that would be an essential point.
Actually, they say it's not an essential point, because the First Amendment doesn't address the speaker. It addresses the speech. Congress shall make no law abridging the freedom, make no law abridging freedom of speech. That, if you look at the language in the First Amendment, I have my handy Constitution here, 1962 edition that I got when I was in law school. I love it. If you look at the First Amendment, which I'm now going to, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, we'll get to that later, or abridging the freedom of speech or of the press. It has nothing to do, it doesn't say it makes no law who can make the speech, it's freedom of speech. The speech is what's important. If the speech is permitted, the identity of the speaker should be irrelevant. That's the point that the Supreme Court is making here. The First Amendment addresses freedom of speech. And Barry, I'm going to get to this whole issue of corporate personhood as soon as we have to break. That's the next thing on my list. But what I'm trying to get at here is that in the Baladi case, which is where where this issue first came up in terms of corporations, the court made a point of saying that the identity of the speaker isn't what's critical, that it shouldn't make a difference. If speech is relevant, if it's free speech, if political speech should be heard, what difference does it make who's saying it?
So Constantine had a question. Unmute yourself.
Yeah, I did. So that's
you can unmute everybody.
That's all well and good now, but nobody, it seems all the way down the line in history, has not made any limits to the amount of contributions. And that is the key. It doesn't matter if it's a corporation or an individual. These days, it's how much you got in a pot, so you could say your piece. And
there's a line in one of the earlier cases that I want to repeat because it's really important. And this was in the Baladi case. The concept that the government may restrict the speech of some element of society to enhance the relative voice of others is foreign to the First Amendment.
I think most people would disagree. They would say that every man's speech should have equal weight, and it doesn't if money's involved.
That's a very good point. And one of the things that gets to, and it's an answer, Irene and Constantine, that really doesn't have a clear answer because it's not a legal issue, it's a political issue.
But that's what we're discussing, the political.
Right, it's a political issue, and the court is a political body. And unfortunately, yes, Irene and Constantine, 6 members of the Supreme Court disagree with your point of view.
Possibly for their purpose.
No, they do.
And one of the problems is when you frame a political issue as a question of law, and you then say that because it's a question of law, the Supreme Court has the final word on it. What does that say to the ability of, in a democracy, of letting our representatives decide political issues? That how much deference should the court give to political issues? And I'm going to get to this almost repeatedly in almost every situation that this comes up. Because anytime you have a case that's decided on the idea of balancing competing issues, in this case, it's is the restriction narrow enough, and is the government issue sufficiently compelling? In voting issues, there's issues. In religion issues, there's a balance between freedom of expression and freedom to and the government interest being protected. Anytime you have that weighing interest, you have a political issue that the court is saying we have the last word because it's a question of law. But really, is it a question of law? And part of the problem is that sometimes your elected legislatures make terrible decisions that are extremely unjust, that are improper, and we want the court to set them right. And I've got examples later on in my talk that I'm planning to make. This is kind of getting ahead of myself. But we remember that many states passed laws that said it's desecration to burn the American flag. We're going to throw you in jail if you burn the flag objecting to the Vietnam War. And thankfully, the court said, no, you can't do that. That's free speech. You had situations where the Congress made it a crime to be a member of the Communist Party or and the Supreme Court said, no, you can't do that. It's a violation of the right of free association. The government interest isn't compelling enough. You had Nixon saying that the New York Times shouldn't be allowed to publish the Pentagon Papers. And the court said, no, the free speech, the free press serves the people, not the government. So you have all these instances where the political decision makers are really being very unjust, and yet it's democratic. So where does who gets to decide?
But wasn't there, I vaguely remember, wasn't there an amount that you couldn't contribute more than as a?
And yes, and that is, but that's another very issues, and that has nothing to do with the McCain fight, with this decision. The Internal Revenue Code has a provision for nonprofit political nonprofit incorporations for political advocacy called Section 527 of the Internal Revenue Code, 527 organizations. We call them PACs, Political Action Committees. In 2006, the Federal Election Commission was asked to make regulations that would tie those organizations into the McCain-Feingold Act. The FEC didn't do it. And the reason they didn't do it is the FEC is set up by Congress to have an equal number of members, half of whom are Democrats and half of whom are Republicans. And for political purposes, the FEC has rarely had a quorum. There's always too many vacancies so that they can't do anything. Because whether it's the Democrats in charge or the Republicans in charge, nobody wants to, everybody's afraid that they're going to make a decision that's going to affect their side. And so the Federal Election Commission never made regulations that would tie 527 PACs into the limitation provisions. So it's not that the act is there's a loophole that for political purposes, Congress has been unwilling to close.
I think it's to the detriment of both sides, political, conservatives, everybody.
Yeah.
So we don't have to
argue that, but
in these days where this kind of communication we have electronically or otherwise, we don't have an equal say. Because today, what matters is how much is in the pot.
Right.
And
when you come and at the very end, I'm going to give you some statistics that are rather unusual, because believe it or not, there's an equal amount of money. And by the way, do you know where the biggest amount of money is coming in elections now? Crowdfunding.
Oh. Individual.
The amount of money that is being spent by PACs is in the millions. The amount of money that's being raised online in small donations is in the billions.
Wow. Okay.
Okay, can we take, it's 10:51. How about if we take 5 minutes right now for a biology break, water, coffee, and what have you?
Okay, good.
Okay, thank you. I'll be right back.
Okay.
I'll turn my camera off.
I don't know if we're. I think we're. Hi, Florence. You're all we're coming and going today because our chimney is draining water from the rain. So you'll see us coming and going with the different contractors.
Am I being heard? I want to say hi to any new people who are here. Are there some new members of Lifelong Learners here?
Your voice was very weak, Lois. I don't know if we're not close enough to your microphone.
I'll move up. I first want to say hi to any new people who are here and welcome. And hope you're enjoying this incredible talk. And then I want to say something to the Fransons, Robert, Marianne.
We can barely hear you. I don't know why.
I wonder why. There must be something I need to do.
Yeah. I mean, was Lois very quiet to other people also? I could just, yeah, okay, yeah.
Yes, very quiet.
If you go into the settings under the mic thing, you select the microphone, possibly that was not selected correct in your own computer. Sometimes it gets out of sync. Oh, I did, yeah.
Okay,
Let's get everybody's pictures back up.
yeah. So, Arthur, one thing in terms of how Zoom works is, although the host can mute people, they can't unmute them. It's your freedom not to speak act.
Okay, I'll mute myself.
You don't have to. It's open time.
Yeah.
Say
Are there any
hello
other
to
retired
Marjorie.
lawyers here? Yes.
Marjorie.
Can you take a question before?
Sure.
What we haven't spoke about, we spoke about the money and everything and the power of the money and all that. Hasn't anybody ever considered the content of the publication? In other words, can we just willy-nilly say anything we want, untrue or not?
That's a good point. The answer is yes. There are a lot of cases on that point, and most of them take the position that there's no censorship.
Okay.
That in a democracy, the free flow of ideas will work. And of course, when you think about it, you have a problem. The problem today is this idea of alternative facts, and this is actually in a way, it's kind of new as a mass movement. Mass media and social media and the internet, as much as they've made things wonderful for so many of us, there's downsides as well. And one of the downsides is the ability of an explosion of willingness to just ignore reality, ignore reality. Traditionally, it's been when you had a fringe group that was, the Flat Earth Committee, is, the only way they could get together and be heard is, they make their own group, but there was no way for people to make use of them for nefarious purposes. And that's what we have today with social media and the way it's, and so, and the fact that there are so many angry people out there. You know, I think, I look at myself, you know, I know, hey, I've lived one hell of a privileged existence. And I know that. And I know that I have every reason to be thankful. But I also know that there's huge numbers of people who just feel totally beaten down with no way out, no way up. And they're just terribly pissed off. And that creates an explosive situation. And the First Amendment, you know, isn't, you know, yes, you have it opens the door to the possibility of great harm. But what alternative? I've always felt the biggest problem with censorship is who's deciding, who gets to decide.
But again, isn't there an issue like the earth is not flat? You can't say it's flat. 1 and 1 does equal 2.
You're absolutely right. And vaccines do work.
I mean, you know, couldn't there be, or isn't there a way to make it constitutional that you can't lie about facts?
I don't know how you do that.
I just mentioned obvious things like 1 and 1 is 2, not 24.
So the First Amendment, that Congress shall make no law affecting freedom of speech except for you can't say anything that's untrue.
All right, then you.
And what about gray areas? How do you decide if something is capable of an absolute truth? And where does faith come in?
Yes, that's exactly right. Now we're getting big area there.
Yeah.
I like to say there are no easy answers.
Well, yeah, there wasn't easy to put this whole Constitution together either, you know, but we did in a way.
We did, and unfortunately, we got a bunch of people who did it in a way that would never happen again. Could you imagine a bunch of people getting together to make a basic political decision about how the rest of us are going to live, and that the doors are closed, the windows are locked, and not one word about what they're talking about is allowed to get out until they're done? Because that's how the Constitution was written.
I know. Yeah, that's true. But sometimes dictatorial, you know, works.
Yeah.
If you have those who are wise enough to do that. I don't know. Yes, it is a difficult problem.
Yeah, and we could literally talk about this forever.
I realize that. So let's go on. I'm sorry to interrupt.
No, please. They're great questions, and this is what we live for. I mean, this kind of exchanging of minds is what makes all of us, makes it worthwhile. Okay. I see a lot of people look to have their cameras off, so I don't know if everybody's back or not.
Yeah, I think we should proceed.
I'm going to proceed. Okay. Now, Barry, to get back to the question you raised before the break, many people are under the impression that the Citizens United case stands for the proposition that under the Constitution, corporations are people, with the word in quotes. This means that the corporation has the same rights as, if this means that do corporations have the same rights as individuals, in many instances they do. The one big difference is we are creatures of biology and corporations are creatures of state law. And under the laws of every state, corporations have the right, like people, to own, buy, and sell property, to make and enforce contracts, to appear in court, to sue, and to be sued. And under the Constitution, corporations have the right to counsel. They have the right to the attorney-client privilege, that attorney-client communications are privileged, whether the client is a person or a corporation. The corporations have the same rights as people to be free from unreasonable searches and seizures under the Fourth Amendment. Corporations are entitled to due process of law and equal protection of the law under the 5th and the 14th Amendments, no more so or no less so than individuals. But on the other hand, corporations do not have a right against self-incrimination under the 5th Amendment. And the Supreme Court has never set aside a fine or reward against a corporation on the ground that it constituted cruel or unusual punishment. So where does this idea that corporations are people came from? I think a brief history of corporations here is helpful. Corporations actually came out of English law. The English rule was, and in other most monarchies, was that the crown could give a charter to a group of people to accomplish a purpose for the benefit of the crown. And that was the idea of the original corporation. The Massachusetts Bay Colony was a chartered corporation. The Virginia colony was a chartered corporation. The idea is that these colonies would serve the benefit of the crown. And in giving the people, giving the charter, they were given certain rights over land and over trade, et cetera, et cetera. So that's where corporations came from. In English law, many roads were privately owned. They were toll roads, or a bridge would be privately owned. And this was carried over to the colonies. For those of you who were here my first class, when I talked about the Charles River Bridge case, I see Christopher is going to say, remember bridges, roads, plank roads, fords, etc. Were corporations, and under American law, it expanded that it would be for business. The public purpose could just be a business purpose. You have schools, roads, bridges, and you also have public corporations like cities. But the use was expanded in America to include general business corporations. And the idea of corporate personhood comes from the fact that corporations, like people, could own, buy, and sell property, make and enforce contracts, and appear in court. But as we've noted, corporations did have legal advantages that individuals didn't. Perpetual existence, unlike a partnership, it's not, the entity's life is not tied to the life of any individual. Centralized management to accommodate passive investors, the ability to accumulate capital from many investors. And by 1815, most states gave investors limited liability. It made it easier to raise money if you told the guy investing that this is the most you're going to ever have at risk. If you join a partnership, you are jointly and severally liable for all the debts of the partnership, even if your interest is a very small one. But a corporation, if you're investing in a corporation, your liability is limited to what you have at risk. And this became the general law during the second decade of the 19th century in America. It didn't become the law in England until the 1860s. And as a matter of fact, a number of states, California included, had shareholder liability built into their constitutions. And in California, it lasted until 1930. If anybody ever wants to know about that, I've written whole reams of stuff on that I could send you. And starting in 1845, let me go back. The way to get a corporation up until the middle of the 19th century in most states was you went to the state legislature and you went to your state legislature and you got him to introduce a private bill to grant a charter to your group of guys to do whatever it is you wanted to do, whether it was to build a bridge or to open a bank or to have an insurance company or to build a road or to have a ford, whatever it was. You went to your local legislature and your legislature would pass a law that would grant you a charter for a set time of years. And it would state in the law, in that charter, what your rights and what you could do, how long, if you could charge money for fees, how long you could do that, et cetera, et cetera, et cetera. But it became pretty clear, especially as the country began to get more what I would call democratized, especially after the influence of the Jacksonian movement in the 1830s, that starting in 1845, there was a trend to democratize corporations. And the way they did this was by the advent of what are called general incorporation laws. In effect, saying that corporations are not a legislative act, but they're now an administrative act. You pass a law that, or you put a provision in, you pass a law that says, if you do A, B, C, and D, the state will issue you a corporation. And you go to the Secretary of State and it becomes an administrative act. You don't have to apply to your state legislature. The first state to put this, to do this was Louisiana in 1845. California put it in its first constitution in 1849. Most states did so by the end of the 1860s. And the idea of corporations grew exponentially with the Industrial Revolution, because with the Industrial Revolution, especially with the advent of railroads, you had business opportunities and business arrangements that, quite frankly, couldn't be served by a partnership. You simply had to raise too damn much money to do it. And so you see this growth of corporations started expanding. And I did statistics on this a long time ago. And one of the things that I found is that and I'll take Ohio, because for many years in the 19th century, it was the bellwether. It was the leader in many things. In Ohio, during the 1850s, they had about 50 new corporations a year. In 1868, it was 380. And by the 1870s and after, it averaged over 400 new corporations a year incorporated in the state of Iowa. By the 20th century, it was up in the thousands. Now, there was pushback from this. Corporations were seen as special interests that used their money and influence to foster their interests ahead of the people's or even the nation's interests. And starting in the mid-1840s and continuing throughout the rest of the 19th century, state constitutions were rewritten or amended to add provisions intended to control or limit corporations' economic and political power. Corporations were called soulless entities. They were motivated by greed, where considerations of family, friendship, or morality didn't temper advancing their economic interests. And this was fought out in innumerable state constitutional conventions and in innumerable state legislatures. You saw this with the advent of railroad commissions to try and control the rates that railroads could charge farmers to move their produce. You saw this in banking and banks. And as a matter of fact, California's first constitution tried to outlaw banks of issue, to outlaw banknotes. Didn't work, but people needed mediums of exchange, but they tried. So, with that in mind, how did the Supreme Court ever get the idea that corporations were protected by the 14th Amendment? Where did this idea of corporate personhood in the law actually come from? And it came about in the late 1870s and early 1880s during the Gilded Age, when the post-Civil War Republican Party morphed into a pro-business party that favored corporate interests and unlimited aggregations of capital to spur economic expansion. And there's a story to it, and I'm going to tell you the story. In 1878-79, California held a convention to revise its state constitution. And remember, this is a time where basically the Southern Pacific Railroad is the biggest entity in non-governmental entity in the state. During the convention, a coalition of farming and working class delegates argued that the railroads, especially the Central and Southern Pacific, which were the same entity, the largest of all corporations at the time, were accumulating massive wealth at the expense of ordinary Californians. Remember, railroads were given grants of land for them to sell, to raise the money to build their railroads. That was the way they were subscribed to. And so, and by the 1870s, the Granger movement was really by the late 1870s, the Granger movement was really in full swing in California. And because the farmers were complaining that the railroads were charging rates to transport, especially short haul rates, were so high that farmers couldn't make any money. That the railroads were figuring out what the goods were selling for, what it cost to grow them, and what the difference would be the farmer's profit, and that's what the railroads charged to move the stuff. And so there was this interest in limiting the power of railroads. And the other thing was that California at this time, this same populist idea, felt that it was unfair to tax people on the total value of their land, especially farmers. They should only be taxed on the equity value, that if they had mortgages, whoever owned the mortgage should pay the tax on that portion of the value. So the California's Constitutional Convention put through a provision in the 1879 Constitution that land would be taxed to the owner of the land based on his equity, and the tax on the difference between the equity and the market value of the land would be taxed to the mortgage holder. And except that railroads would be taxed on the full value of their land. Now, the railroads took the position that all their land was leveraged 100%. Because all the bonds that the railroads sold said that all their assets were pledged to support the repayment of the bonds. So the railroads argued that, hey, under this law, it's unconstitutional because it denies us, there's no logical reasons we are denied equal protection by taxing our land differently than other people's land simply because we're a railroad. And the law, the constitutional provisions specifically set aside railroad owed lands to be taxed differently. So so obviously, if you want to know what happened next, well, the Southern Pacific did what any good person's going to do. They ran to the courthouse. And they filed a lawsuit arguing that the state constitution's tax rule violated the new 14th Amendment's equal protection laws. Remember, the 14th Amendment was less than 10 years old, barely 10 years old at this point. Now, in the trial court, the Southern Pacific was represented by a former New York congressman and senator named Roscoe Conkling. Roscoe was a well-known, well-connected Wall Street lawyer. He was so successful that on 2 occasions, he had turned down nominations to the Supreme Court. Grant nominated him to be Chief Justice, and he said, no, I don't want to do it. And later on, I think it was Chester Arthur, nominated him to be Associate Justice, and he turned that down as well. Now, Conkling had, during the 1860s, as a young congressman from New York, had been on the joint House-Senate committee that had a hand in writing the 14th Amendment. And Conkling, when he's arguing the case whether or not the Southern Pacific Railroad is entitled to have its land taxed the same as everybody else's land, which meant no tax at all, Conkling claimed that he kept a journal which reflected that the original draft of the 14th Amendment changed the word citizen to the word person to describe who would be entitled to due process and equal protection in order to include corporations. And this is the argument he made to the court. But Conkling lied. When he died, his journal came to light, and it said nothing about the word being changed from citizen to person, or the corporations had been discussed at all. In fact, the second sentence of the 14th Amendment, I'm going to share my screen here. The first draft, the second sentence of the First Amendment, of the 14th Amendment, I'm going to read it right now. Here we are. The second sentence, no state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This was written by an Ohio congressman named John Bingham, and he wrote this, and the records of the congressional committees are sparse, but there's no mention in any of them of corporations. And the first draft that Bingham presented to the House used the word person as being entitled to due process and equal protection. That's on the left-hand side of my slide here. Bingham's diary, speeches, and letters made no mention of corporations in the context of the 14th Amendment. In fact, later, after the 14th Amendment had been adopted, Bingham spoke in Congress on behalf of a bill that would specifically extend the Privilege and Immunity Clause to corporations. Now, the bill wasn't passed, but this suggests that Bingham didn't believe that corporations were constitutional citizens. In any event, the die was cast. When Southern Pacific Railroad versus Santa Clara County was argued in the Supreme Court, the then Chief Justice Morrison Waite, he was an Ohio politician who had been appointed by President Grant after Conkling had turned the gig down, supposedly told the lawyers not to argue whether the Equal Protection Clause applied to taxation of corporate property, as the Supreme Court assumed that it did. But this assumption that corporations are covered by the Equal Protection Clause is not in the court's opinion in the Southern Pacific Railroad versus Santa Clara County lawsuit. It's not in. The court ruled for the railroad, but on non-constitutional grounds. In fact, in a separate opinion, another justice, Stephen Field, castigated the majority for dodging the question whether these Equal Protection Clause applied to the corpse, which Field believed the case. In fact, there's evidence that Justice Waite said no such thing. Now, how did this happen? The Supreme Court reporter of decisions, this is a job, it's called the reporter of decisions, and he's an employee of the court. And he's the one who's charged to prepare each opinion for publication and writing a synopsis that will summarize the facts and the holding that will appear in the bound volumes before the opinion. And the synopsis that he wrote for Southern Pacific versus Santa Clara County indicates that Chief Justice Waite supposedly said about the Equal Protection Clause applying to corporations. The court does not wish to hear argument on the question whether the provisions of the 14th Amendment to the Constitution, which forbids a state to deny any person within its jurisdiction the equal protection laws, applies to these corporations. We are of the opinion that it does. But Waite later said that he hadn't reviewed the synopsis before it was published, and the court stenographer of the argument, of the actual arguments of counsel, did not include this comment. Nonetheless, this case continues to be cited as authority that corporations have the same rights as people under the Constitution. That's where this comes from. It comes from the fact that the reporter of decisions put something in here that probably the Chief Justice never said, that for some reason, the reporter of decisions felt that it was the case because this was the opinion of this was the main argument that had been made in the court below. So that is where this comes from. But I gotta say that I don't think personhood is the core issue. It makes for a good soundbite, but in some instances, corporations do have attributes of people, especially when it comes to their property. And I don't think that's ever going to change. Corporations are too important for our economy. Too many things in our economy require huge accumulations of capital that you're never going to get unless you offer people limited liability and you have centralized management and perpetual existence. They're absolutely essential to the operation of our economy. More so than they ever have been. Rather, I see the core issue being the scope of free speech clause in the First Amendment. How absolute is it and who gets to decide? Who gets to decide? Congress shall make no law abridging freedom of speech. That's the language. But Congress never took it as an absolute ban. In accord with the English common law, The 1798 Alien and Sedition Acts that were put through in the last 2 years of John Adams' administration made it a crime to publicly hold the government in disrepute. This was called sedition. And the idea that developed in English law was that if you criticize the government in such a way that people aren't going to have faith in their government, that they're not going to believe in it, that they're not going to honor it, that this works to the disadvantage of the state and it should be illegal. That's what the common law of sedition was. And the Alien Sedition Act enacted it, and Congress passed it. The court never acted on it because it had a sunset clause. It died as soon as it expired, as soon as Adams' administration was over. And when Jefferson came in 1801, one of the first things he did was pardon everybody who'd been convicted under the act and remit their fines. Now, going on, press censorship was unchallenged during the Civil War. When we joined World War I in 1917, Congress passed the Alien Acts and the Espionage Act of 1915. And that made it a crime to resist the draft or argue against the war. The Supreme Court upheld the espionage, calling opposition to the war and urging draft resistance a clear and present danger, no different than crying fire in a crowded theater, was the way Oliver Wendell Holmes stated. And by the way, this espionage is still on the books. Today, the test that's applied to limits on political speech is a two-part formula. Under the highest level of judicial scrutiny, what they call strict scrutiny, the idea is, are we merely sure, or are we sincerely sure? You know, one of the things I love, it's a line I always like to use, is from The Wizard of Oz. If you remember when they're celebrating the death of the Wicked Witch of the West, the coroner comes up and he says, and he sings, I certify that she is not merely dead, she is most sincerely dead. Well, strict scrutiny is sincerely. I consider it the difference between merely and sincerely, and I'm going to use this in other talks too. I've got it. I think it's a great line. In any event, under this strict scrutiny, does the state have a compelling interest that justifies limiting the speech in question? If so, is the limitation framed as narrowly as possible to serve the interest and yet allow the greatest possible freedom of expression? These are all very nebulous lines. There's no line in the sand. It's like drawing a line in the sand while the tide's coming in. Just doesn't happen. And having the Supreme Court as the last word when balancing competing interests is a hard question in our democracy. We talked about this before the break, and the question that you guys raised, it's absolutely critical. In our system of checks and balances and mixed government, the Supreme Court has long held that it has the last word on what is the law. This goes back to John Marshall's opinions in Marbury versus Madison and in McCulloch versus Maryland, where the issue came out. You know, does Congress or the court have the right to say what the law is? But isn't balancing competing issues a political question as opposed to a bright line that never moves? Yes, it is. So how much deference should courts give to determination that the people's representatives, the legislatures, to determine whether or not the state's interest is sufficiently compelling? Maybe a lot. But then elected politicians can be swayed to make terrible decisions that are patently unfair and due to political considerations, often the political consideration being the public inflammation at the moment. Consider, over the years, many states passed laws making it a crime to burn or denigrate the flag. The Supreme Court held that that's unconstitutional when it's a political statement. During the Cold War, most state legislatures banned the Communist Party and pro-communist activity, but these laws were struck down under United States versus Dennis and many other cases by the First Amendment. We've established criminal penalties for hate crimes, but one person's hate could be another person's firmly held political belief. What and where is the line drawn? What standards apply? What words are so odious that they should be outlawed? What about coded language that avoids the usual buzzwords but clearly has the same meaning in our culture? There are no easy answers.
Yes, there are.
I mean, that's where I've come down. There are no easy answers. So we take the facts one case at a time and do the best we can. Now, early 20th century progressives believed that the needs of millions of citizens were being ignored, and they favored limiting lobbying and campaign contributions to reduce the influence of big money. And this goes back to the early 20th century. In 1907, Congress passed a law called the Tillman Act that prohibited corporations from making direct contributions to political campaigns for federal offices. This is when campaigns were always run by the candidates in the political parties. But the act had little impact because it didn't have any effective enforcement provisions. In 1910, Congress imposed spending limits for House and Senate candidates. And in 1925, the first Federal Corrupt Practices Act imposed general campaign contribution limits on people and corporations alike. They didn't want the idea that people could give money in unlimited amounts to buy access or to buy favorites. In 1930, the Hatch Act set annual campaign spending limits and a limit of $5,000 by an individual or corporation to any one campaign. And in 1947, the Taft-Hartley Act extended that ban to labor unions. And we've already mentioned the post-Watergate strengthening of the 1971 Fair Election Campaign Act that was at issue in Buckley versus Valeo. Now, in enacting the McCain-Feingold Act, Congress tried to solve two purposes by limiting how and when corporations could spend money. One was to avoid corruption or the appearance of corruption, that is of spoken or tacit quid pro quo arrangements, or including the appearance of gaining greater access to elected officials. But we do this anyhow. I mean, how many of you have read about when a candidate comes to town for a party, that you can buy a table for X dollars, or if you want to give Y dollars, you get invited to a pre-meeting, and if you do Y times $2, you can actually have a private conversation to get a picture with the candidate. So this is part of our culture. So one idea was to try and eliminate this. The other was to equalize the voices could be heard. What we've talked, Irene, what we've talked about, the idea that we shouldn't allow money to talk to drown out other voices, that there should be a way of equalizing the voices so that corporate money couldn't drown out other voices. And Congress deemed that they were necessary to improve both the reality and the public perception that elections were free and fair. But in Citizens United, the Supreme Court held that any limit on what corporations could spend, no matter where the money came from, for political speech was an unconstitutional restraint on free speech. So corporations and labor unions have the right to engage in political speech, the same as individuals under the First Amendment. And neither preventing the appearance of corruption nor equalizing relative voices were sufficiently compelling to justify limiting a corporation's right to engage in political speech. And they did because, in their view, unbridled political speech is necessary in our democracy. It serves our democracy. And thirdly, Congress did not draw the limitations sufficiently narrow enough, given the regulations that were involved for corporations to set aside money for this purpose, and because the statute required virtual pre-clearance. But as President Obama noted when he called out the Supreme Court's decision, that the majority ignored 100-year precedents to the contrary. So that's where we are. But I want to finish with a look of, because the Citizens United case is now 10 years down the road, 11 years down the road. And apparently it did not result in an avalanche of corporate spending in election cycles. As the chairman of Procter & Gamble's once said, we're in the business of selling toothpaste, not candidates.
Bullshit.
Right, but that's what he said.
I'm sorry.
But it didn't result in an avalanche of corporate spending. Rather, ruling that all limits on expenditures were unconstitutional resulted in a flood of individual and family trust money into PACs. As reported by the New York Times, the biggest spenders in the run-up to the 2018 midterms were individuals to PACs. PACs, as I mentioned, are these IRC Section 527, Internal Revenue Code Section 527 organizations that are free from any limitation on what they can spend on political speech. It has nothing to do with McCain-Feingold. It's just that's the way the law is. There's no limitation on it. And the biggest donators in the run-up to the 2018 midterms were Sheldon Adelson at 122 million, Michael Bloomberg at 95 million, and Thomas Steyer, the California guy, with 73 million, with George Soros and Jeff Bezos close behind. And only Adelson is tied to conservative causes. Yet reportedly, corporate spending was relatively insignificant in 2018 or 2016 cycles. The biggest boom has been the growth of internet-driven grassroots fundraising directed at small individual donors. This exploded in Obama's campaign in 2008 and 2012. And the final thing I want to say is in the 2018 midterms, the vast majority of $16 billion raised for Democratic House candidates came from Act Blue, which was grassroots fundraising of under $200 a pop individually. That's where the biggest money is coming from in terms of campaign spending, other than PACs. So that's really where we stand. I don't have, I don't have an answer. I read you guys you've all raised this fascinating political question. It has historical roots, but there is no easy answer